Hello and welcome to our webinar utilizing cutting-edge eDiscovery collection processes to achieve proportionality. Thank you for joining us. We're glad that you could make it. My name is Karen Hayworth and I'll be your host today. I would like to introduce John Patsakis. John Patsakis is the founder, executive chairman, and chief legal officer of X1. John has an extensive background and expertise in e-compliance. And prior to joining X1, John spent nearly a decade at Guidance Software, where he held several senior management positions, and prior to joining Guidance, John spent 8 years practicing law in the fields of commercial litigation and business transactions. And with that, I'll turn things over to John to discussion. John?
Thank you, Karen, and wanted to thank and welcome all of our attendees. Looking forward to a great discussion, really important topic, and we're going to delve into the law of proportionality, but also try to give you some practical guidance on how to apply that. And we have a great panel to, I think, lead in that discussion. First is Kelly Twigger. Kelly Twigger has been an attorney for over 20 years, focused on eDiscovery and information law. Kelly founded ESI Attorneys in 2009 and works with clients such as Fortune 50 and 250 companies, law firms of all sizes and specialties, and municipalities to help them do better business through smarter, more efficient eDiscovery practices and procedures. Kelly is really one of the top eDiscovery attorneys in the field, so really excited to have her on the panel. Welcome, Kelly. Bill Belt is a managing director at Complete Discovery Source, great company. We're excited to have Bill as well. Bill is both a consultant and an eDiscovery attorney. He's got 25 years of experience as a partner, shareholder, and board member of AmLaw 200 law firms, including Williams Mullen, where he built one of the first law firm eDiscovery practices. Bill has extensive experience as trial lawyer, including trying to verdict over 20 jury trials, and he also has deep experience in legal tech, including working with AmLaw 200 firms, Big Four, and technology providers. So welcome, Bill.
Thanks, John.
And then last but not least, Alan Long from X1. Alan is the Senior Director of Solution Consulting and has over 15 years of experience focused on the use of and implementation of eDiscovery, data governance, and machine learning applications. Alan will be leading kind of a interactive technical discussion on remote collection capabilities, as well as applying those concepts to the concept of proportionality that we'll be discussing. Okay, so in terms of the agenda, so we're going to talk about the overall eDiscovery collection landscape. But first, we're going to delve into proportionality and eDiscovery, first talking about the overall concepts, and then getting into the elements and the case law. And then we're going to talk about the process of proportionality and how that is structured in the field and how do you approach it in your cases and what tools we have, such as I think Bill's going to discuss the George Washington Law project, which puts a kind of a process around the concept of proportionality to help operationalize it. And then we're going to have a kind of a live exercise that won't be so much of a product demo as more of a technical overview and on an actual live case demo using some of these concepts we discussed in the webinar to try to make it a little more interactive for you. So looking forward to that. And then Q&A will be important, so we'll make sure we leave time at the end for questions. We've already got a few questions in, so as Karen mentioned, please use your chat log feature to submit questions. Okay, so Kelly, starting off with you, you could please give us an overview of proportionality first in terms of the overall principles and its frequency that you're seeing in the case law.
Sure. Well, I think what's really important is that we consider that proportionality has always been in the Federal Rules of Civil Procedure, but it was kind of buried. And it wasn't until the 2015 amendment to the Federal Rules of Civil Procedure that the Rules Committee really brought it front and center and put it in not only in Rule 26, but then issued referrals to that section of Rule 26 that deals with proportionality in multiple other rules, including Rule 34, Rule 1, across the board of the rules that were amended. So really that's what's key. What you see on your screen right now is a map of case law from our software, which is called eDiscovery Assistant. eDiscovery Assistant is a database of case law, checklists, and forms and rules that deal with electronic discovery. It's a piece of software that we built for use at our firm at ESI Attorneys and have just subsequently made available to folks. So if you're interested in that, you can check that out. What we put here is a map of case law for cases that we have issue tagged with proportionality. So one of the features of the software is that we review all of the decisions and tag them with a set of eDiscovery related issues. And so you can see here that just from the time that we pulled this map, which I think was about a week ago, we've already got 459 cases that deal with proportionality considerations just in 2021. So that's pretty phenomenal. Last year in 2020, we had more than 800 decisions that dealt with proportionality. It was kind of the highest ranking issue that we saw in our 2020 case law report. So I think, Karen, if you'll switch to the next screen, we can talk about what really Rule 26 considers when it looks at what is proportionality mean. And I think what we're going to see when we talk about some of these cases, and I'll encourage Bill to dive in here as someone who's dealing with the data with his clients, is that there are six factors that the courts look at in determining proportionality. What we see in the case law more often than not is not an enunciation of these 6 factors, though. We really just see the court considering based on multiple factors in the case, what is proportional to the needs of the case. And the cases that we talk about today with regard to proportionality are strictly ones that relate to collection, forensic examination, things that are crucial to our topic today, because with 500 cases for the year, we could talk about proportionality for the rest of the week.
Yeah, can I jump in there, Kelly? One of the more interesting pieces I think that you'll find is that the case law is more and more delving into the details of technology. So whether it's the importance of issues in the case, the burden or expense, the proposed discovery, you are seeing more and more cases where courts are talking about what it really means to collect this data, and the burden being a technology burden, but also the technology solutions that are available to solve those problems. The judges are willing to go there. So I think that's what you're going to see today.
Yeah, I think that's a really important point, Bill. And I also think that it's worth noting that we're seeing the development of the case law in the jurisdictions where we're seeing a lot of eDiscovery case law. So 7th Circuit, the 2nd Circuit, the 9th Circuit, Florida, in the 10th Circuit is really, or the 11th Circuit, sorry, is really, we're really seeing a lot of decisions out of there. So when you are making arguments about proportionality for your case, do not limit yourself to your own jurisdiction in terms of doing your research. Make sure that you're looking broadly at how courts are handling these issues across the country.
Yeah, and one thing too, Kelly, to comment on is that people think that proportionality involves costs, which it does, but there's also a tie-in to data relevance, the data being proportional to the claim, the defense of the case. And like some of the case law that you're addresses that. Maybe a little color on that.
Yeah, absolutely. I mean, you mentioned it kind of before we got started today, John. We recently talked about a case, the Blankenship case, which is not one of the cases that we're covering today, but it illustrates that point really well. That's one that you can look at from our case of the week that we do each week on our blog at eDiscoveryAssistant.com. If you just search for Blankenship, you'll come up with that case. But there, it was really crucial that proportionality was a completely different consideration because those claims were broader. And some of the cases that we're going to look at today, we're going to see where the courts really narrowed the consideration of information that can be available based on the claims and the relevance and what has to be shown.
On relevance, it's also nice to see decisions clarifying that relevance is table stakes. There was back when I was trying cases, you sort of had to go to court ready to fight that fight. That the judges were thinking it was either relevant or reasonably calculated to lead to the discovery of admissible evidence. So to put that argument to rest is one great advancement that we've seen court decisions make.
Well, and that's another key component of the rule changes, right? I mean, they eliminated reasonably likely to lead to the discovery of admissible evidence from the federal rules. So now it's just relevance. And that is a clearer standard than reasonably likely to lead to the discovery of admissible evidence. So we do have a lot more guidance from that perspective. It feels like we're inching closer and closer and closer to rules that could actually give us some guideposts. So I'm happy about that.
Okay, great. All right. Great insight. And so, in fact, let's talk about some of the specific cases, I think, where the courts apply proportionality or the overall concepts. And these cases come about where the parties have a dispute over the eDiscovery process and results in this kind of case law. So please walk us through some of these cases, Kelly.
Sure. So the, I'm going to say Diepenhorst case. I don't know if I'm pronouncing that correctly, but this is a case from 2006. So this is prior to the rule changes in 2015 that really put proportionality front and center. This is a case that involved a request to have a mirror image made of the plaintiff's hard drive for inspection by the defendant. And the defendant did not want to have any supervision associated with the making of the image or the review of the image. This was a criminal case, and so the plaintiffs wanted that supervision. The court made a really interesting comment here that defines forensic examination, and it really sets the tone for all of the cases that we talk about today, and when you're looking at forensic examination and whether it is proportional to the needs of the case. And the court said, inspection or testing of certain types of ESI of a responding party's electronic system raises issues of confidentiality and privacy. And the key quote here is, the addition of testing and sampling to Rule 34A with regard to documents and electronically stored information is not meant to create a routine right of direct access to a party's ESI, although such access may be justified in some circumstances. Courts should guard against intrusiveness resulting from inspecting or testing such systems. So what the Diepenhorst case really looks at is, what's proportional given the fact that we generally say you can't get into a party's ESI systems. And so there are very few reported decisions allowing the image of an opponent's computer hard drive, and that it's an expensive process and adds to the burden of litigation for both parties. So here, it allowed information, but it was really narrow in terms of what they gave. And so this is kind of the beginning of proportionality within the context of collection. And it's a really important case from that perspective. Bill, what are your thoughts?
Yeah, it is an important case because we also see a growing tendency or danger of encroaching on what the Sedona Conference recognized and set Principle 6 to oppose, which is parties to litigation have the ability to control their own destiny, to control the process by which they conduct discovery. And it's not appropriate to simply open the doors to the warehouse in the old days or hand over the keys to your client's data systems and let them sort of have at it. This case is a very refreshing line of cases that is recognizing what many people will recognize as a core principle of the Sedona 6. So yeah, good case. And it cites the old Ford case, which kudos to the judge in that case, set that chain of string of case law in the right path.
Yeah, and what we've seen is that the case law has really developed from the Ford decision, including this case as well, and really showing that imaging is only really appropriate where you find that the opponent's document production is inadequate, and that you have a need to recover deleted materials. I do think when you juxtapose this case with perhaps an internal fraud investigation or other situations where forensic examination may be necessary, that the facts sort of change, but that's really what the point of proportionality is, right? Relevance, facts, what's happening in the case are all what impacts your proportionality analysis. You want me just to jump to the next one, John, or you got comments?
Just brief comment on the Sedona principles that Bill mentioned. There's also a great quote about full disk imaging, and this is in the 2017 version of the principles, how a civil litigation is not a crime scene. It should not be treated as such. So there's really a strong degree of disfavoring full disk imaging as over collection as a routine process in eDiscovery. There are situations where if you suspect required, but so actually we're going to provide a white paper after this to all the attendees, written primarily by David Horrigan, the esteemed eDiscovery attorney at Relativity, that really delves into the Diefenhorst case and many others, including the Sedona principles. So look for that for the attendees. Okay, yes, please tell us about McMaster.
So McMaster is a decision from July of 2020, right? So we're 5 years after the changes to the federal rules, adding proportionality front and center. This is an ADA case related to the termination of plaintiffs for age discrimination from Kohl's department store. In this instance, there was a specific custodian who's believed that her sole role was taking a text message from the plaintiff who had asked for the suicide prevention hotline for Kohl's, and her making a phone call related to that. Ultimately, they asked for emails from that same custodian related to the age discrimination and arguing that they were relevant to establish a pattern of discrimination. And the court looked at, like we've already talked about, the relevancy of the claims here and said, not only did those emails need to be produced, the court also looked at the specific date ranges of other custodians whose emails needed to be produced. And they really addressed them to maintain proportionality. You know, when did each one of those custodians start their employment? What kind of involvement did they have? And so when you're coming to the court with proportionality considerations, you need to address them factually for your individual case. When was each of your custodians available? When would information have been created for them? You know, tell the court the facts that it needs to learn to do the proportional analysis. In this particular case, there was also one thing that I wanted to note that I know you guys are all aware of, but hopefully the audience will at least take to heart. And one of this is the court addressed search terms here, which were also subject to the proportionality consideration. And the court goes back to cite a decision from Judge Facciola in O'Keefe from many years ago, in which the court really cautioned lawyers and judges from getting involved in the search term process, that it should allow the data to really determine what the search terms are from a proportionality perspective. And that, his quote, which everybody knows about, is that for lawyers and judges to dare opine that a certain search term or terms would be more likely to produce information than the terms that were used is to truly go where angels fear to tread. And in this particular case, the judge declined to go where angels fear to tread with regard to the search terms and required the parties to go back and do that. Bill, what are your thoughts here?
Yeah, this is one that line of cases, I cite O'Keefe all the time to my clients, where angels fear to tread, and for the moviegoers that like the first part of that quote is fools rush in where angels fear to tread. But the point being, get the experts involved early, the technology experts. There's a lot of development in technologies that handle search terms. And to not use the experts is a missed opportunity. You kind of see it in these motions. A lot of these motions you read them and are a little bit surprised on the way they go. But if you look at them, one of the determinative factors is, did they get an expert involved early? They should have had an expert affidavit when they filed the brief, when they responded to the brief. The courts really react negatively to, like he says, attorneys and judges making technology arguments without really understanding the weedy weeds of the technology. It's often a case of not what happened, but what could have happened, what went wrong, and why did it go wrong? And for that, you need just somebody to sit there and talk about it from a real techie perspective.
Yeah, I would add too that experts in highly technical, complex cases are really important, and we act as experts a lot, and as I know you do as well, Bill. But you don't always need an expert. What you need to do is get into the data, get into your Office 365 and run some search terms and see what kind of results you get. Compare those search terms to when you pull data out in your eDiscovery review platform and see what kind of results you're getting so you can start understanding these things. These are not concepts that lawyers can't understand and can't get involved in, but until you start looking at the data, you will not really understand these concepts. So if you're not going to get into the data, definitely get an expert.
That's a really good point, Kelly. So let's, and then Bill, I know you know a lot about the Lawson versus Superior Systems case. I know that the judge spoke to the panel at GW Law, so maybe you can delve a little bit into that case.
Yeah, so Lawson is an interesting case because it brings to the surface the TAR process and a deep evaluation of what was done. Lawson's an interesting case because the plaintiff was the CEO of Spirit, so there was a tentative or tenuous agreement that the CEO was going to pay for the discovery. But the case goes deep into every aspect of the discovery process and whether the costs are reasonable. So when you're talking about the reasonableness of reviewer cost, hourly rates. But for me, the most interesting part is where they get to the TAR process and the court allows a 85% recall rate as a cutoff decision. I think people are going to be citing back to Lawson for years to come. Like you say, John, we talked about that at the GW Proportionality Conference, and we had counsel who argued that case on the call. And when you delve deeper into the statistics and the technology and the arguments that are available to a party that's using TAR, they're strong. So if you cut off a review, once you get to an 85, or a lot of times it's 75 and 80% recall rate. In other words, we believe that we have found 75 to 80% of what's relevant in the data set, we can stop. There's a lot of underlying data that makes that argument a solid argument. But in terms of saving costs at the review end of the spectrum, Lawson is going to be a case that I believe parties are going to be going to for years to come.
I think one of the important things for me in this particular decision on Lawson, and so if you're not familiar with the Lawson case, there were, I don't know, 11, 12 eDiscovery related decisions out of Lawson. Basically, they fought about everything that was possible to fight about. But here, Lawson objected to the costs associated with TAR and claimed they were not proportional to the needs of the case after TAR had already been run. So if you want to argue proportionality, you need to argue it before you engage in the processes. And the court basically said, hey, even if you had a consideration for arguing that TAR 1.0 should have been used as compared to TAR 2.0, you needed to raise that before the process was done. So it's too late. So timing is key when you're arguing proportionality as well.
Yep. Excellent. All right. So speaking of timing, we're moving on to the great point though, Kelly. So these two cases delve into collection more and proportionality. I think also taking a cue from the diving horse case. So maybe Kelly, give us a brief overview.
Well, the Ramos case is about the forensic imaging of a cell phone. And essentially what the court looked at is said, this was a TCPA case. And so in TCPA, if you're texting someone or calling someone that has said they don't want to be texted or called, the very fact that you've texted or called them is a violation of the TCPA under federal law. And so in this particular case, the court said, you don't need a forensic image. You've already admitted that you called the plaintiff, and she's already shown you a screenshot of the text message. So there was no basis. So it was really, again, a relevance kind of issue. In Crane was different because we were talking about a theft of trade secrets practice. But again, kind of going back to the point you made earlier, John, or was it Bill, who said that civil litigation is not, criminal context. You don't get to it's not a crime scene. In that particular case, Crane could show that there were, or I guess the plaintiff could show that there were USB images or USB devices that had been plugged into the hard drive, but they couldn't show that any confidential documents had been downloaded. And the court said, much as we saw in the Dipenhorst case, that absent a display of not producing all the documents you're required to and some other basis, we're not going to grant you a forensic examination.
Yeah,
okay.
One last point on that one, John. It's to Kelly's point about knowing your data. It's also knowing your facts. The testimony from the witnesses in their depositions was we didn't have any confidential information, and the times we did use thumb drive, it was at EDI's request. So the lawyers, needed to get that stuff squared away before going to court with a motion.
Yep.
All right, great analysis, guys. Okay, so now, Bill, you mentioned you've been involved in this, what I think is a very important project at GW Law that is addressing not just the laws of proportionality, but actually applying it through a systematic process. Could tell us more about that?
Okay, so yeah, we have gotten a group together. It's practitioners and attorneys, like you see, a lot of judges. There's a strong interest from the bench, and I think it largely reflects the sense that when you read these cases, you get a sense of judges that are 2 steps removed from the technology and the critical facts that would help drive their decisions. When the rules were changed at the end of 2015, like Kelly said, raising the profile of proportionality, that was great. But now we need actually some workflows and some boots on the ground processes and strategies to make that happen. When you talk to teams that work on discovery and eDiscovery, they bring the concept of proportionality to every matter. I mean, everybody has in mind, well, is it going to make sense? If I have a list of potentially half the company as custodians, does it make sense to really grab data from all those custodians? No, it makes more sense to be proportional, identify the right custodians. And in addition, one of the things we're breaking down a little bit with more detail is let's talk about those custodian specific data sources. And then let's talk about how those data sources and the data from those sources play out and what costs they incur, what burdens are involved as you take that data downstream from collection to processing to review and production. And we're developing a framework that includes a calculator, that includes ways to document the arguments that would support a proportionality argument, and also gives you a roadmap for both your internal work product, information that will never see the light of day, but also information that is going to be part of negotiations with opposing counsel. We have 4 teams set up working on the relevancy factors, and that's, Kelly pointed that out, it's not just burden. There's 6 factors listed in Rule 26, and you need to look at all of them. And then the data sources are changing all the time. The technology underlying those is changing all the time. We had some great conferences in 2021. We're now putting together, as part of the calculator, a calculator that deals with what we talked about in Lawson, the TAR process, so that we can bring cost savings to an evaluation of burden early on in a case. And you'll see more about the GW group putting on more presentations and seminars in 2022. So those are underway. A lot of exciting work going on, and you'll hear more about it.
John, can I just add something real quickly, because we tend to, sometimes when we have these discussions, we're thinking about really high dollar litigation. And the reality is that proportionality has a significant impact on very small cases. So organizations that have 400 and 500 matters a year have a large part of those are employment cases, and they may be smaller matters with smaller amounts of information and very targeted requirements. And proportionality is very key for those kinds of employment cases. Oftentimes we have clients who have counsel who specialize in employment matters that handle those kinds of cases for them, and they're not always as eDiscovery savvy as other attorneys may be. So it's really important for in-house counsel to be aware of proportionality and understand those factors for purposes of managing those smaller litigations as well. Costs can be such a huge deterrent to those employment matters that it's important to consider proportionality. Yeah,
I think really important points. Okay, and then finally, just from Bill, I mean, you're on the front lines on eDiscovery collection, and tell us about some of the challenges with the traditional approach and what you're doing to streamline eDiscovery collection and processing.
Yeah, I think it comes down to control. You know what? It comes down to what Kelly talked about, knowing your data. Knowing your data and having control of your data so that you can make actionable decisions early on in the litigation. So this is a nice chart that shows sort of the traditional approach. It shows one of the things that's a bane of my client's existence, which is the time factor, the time cost of doing a traditional approach. And I can tell you that the courts are probably 4 steps removed from considerations. In their minds, no longer do they think it's an easy button and a one-day deal, but they think everything can be done in 2 to 3 to 4 weeks. And in a traditional process, it just can't. If you apply proportionality and you do some of what Kelly's talking about, get ducks in a row in advance and use the right technology and really get a handle on your data, then you're still not going to get a 8-week process down to a 1-week process, but you're going to get a lot closer to it. And I think, John, you're probably going to tell me that in some cases you will get to a 1-week process. So that's probably doable. But the key is gaining control of that data, knowing your data, and then making actionable decisions that are directly relevant to what the rules have put in place for every party, which is proportionality. The cases, the discovery process in a case must be proportional to what's involved in the case, and having the ability to make those decisions to keep that process proportional.
Yeah, one thing that in talking to both you, Kelly, and Bill, is that what I hear you emphasizing is getting involved in the process early and applying proportionality early. Like the Lawson case, the ship had sailed by the time that proportionality issues were discussed. Also on collection, if you're getting a full disk image and you're collecting everything on the hard drive, it's kind of hard. The ship has kind of sailed almost in terms of proportionality, right? So starting early in the process, it seems like, is the key to getting the benefit of the proportionality principles. I don't know if you guys have any insight into that.
Yeah.
I mean, here's what I would say about that, and Bill, I'm curious to see your experience as well. But we have done remote collections for years. I mean, pre-pandemic, we were doing remote collections and have been for our clients for years. So there are limited situations in which there is a need for a full forensic image of a hard drive. We set up processes for clients to do them when people exit the company that may be a legal hold custodian, because at that time we don't have a basis for understanding the scope of the information that might be relevant. If you have a scope of information that should be relevant for a matter, there are limited situations where the full image of a hard drive is going to be necessary when you don't need some sort of forensic examination. You're not looking at a theft incident. Bill, what are your thoughts?
Yeah, I mean, that is definitely true. And we talk about Sedona has spoken to it now. The third edition of Sedona makes it clear that these are not crime scenes. The old days of going out and doing full disk images of hard drives are done. Same with mobile devices. You read in these cases that we just cited that the courts are going to require a targeted collection of mobile devices, probably even more so because there's so much private data. But that's just as true on a hard drive. People probably don't even realize how much personal information they have on the hard drives of the computers that they work with day in and day out. And one of the things that we contend with in our trying to determine burden for a hard drive is how many gigabytes in the typical case are we going to take from a hard drive? And you look at the typical hard drives that are out there today, and they're upwards of a terabyte of data sitting there on your computer. But even the 280 gig hard drives, are you really going to take 280 gigs of data from a custodian? It doesn't make any sense.
No. And then the cost to parse all that once you get it, and what you load into a review platform. I mean, it's just so much better to do it at the collection stage.
Exactly.
But that requires thought process and strategy associated with collection. You have to have somebody working with the custodians and making sure that the processes that you're using to collect and the information you're identifying is reasonable. That's our standard. And so, one of my big constant plugs every week when I do our Case of the Week series is you need to document everything you're doing. So as you're discussing with a custodian and you make a choice to collect or not to collect, that needs to be documented.
Okay, well, this has been an excellent discussion. I wish we had another half hour. Unfortunately, we don't, but this has been tremendous. Again, it's been a great panel, great discussion. So what Kelly just said is a great cue, I think, for Alan to show and kind of really apply a lot of these concepts of getting insight in the data early, getting intelligence around that data, conducting remote collections, applying all that. So I'll let Alan take it from here.
Hello there, you guys. Thanks, John. A great conversation. And what I'm briefly going to show on the screen here, just for about 3 seconds, is this is what a typical hard drive would look like. You mentioned to build a 250 gig hard drive. Here's a simple hard drive that has over 188 gigs of data. And when you look at what the Windows directory, which is the operating system, and you look at other things like program files exist, most user-created content exists within the user directory, the My Documents directory, the desktop, other different components. Although there might be outliers, with mail PST files from a previous year being archived. But you're looking at a fraction, about 1/3 of a disk drive image might potentially yield relevant information. And when you target that relevant information, or at least preserve this information, in your point, Kelly, executives leaving the company, we don't need his whole disk. We just need his user-created content. So that's just a snapshot that I wanted to set, kind of some baseline. I think you guys talked really about, targeted preservation. What we'll go through right here is things have changed. If anything, we've known over the last year, or Kelly, as you mentioned, for years you've been doing remote collections. Technology has changed. Access to data has changed. Bill, you mentioned the locations of the data has moved around the companies. Many people are going cloud-first strategies. Some still have legacy systems that they have to access and they can't migrate off for numerous business reasons. But with this particular concept that we're talking about here is really in-place data interrogation that can happen early in the case. We're going to show an example here where I called it an in-place ECA investigation. And if I was called in as a consultant to look at the SALT versus Black project that I'm kind of going to take a look at, I have the ability to look at large data sources in their native environments and provide real statistics. One concept that I constantly get asked is, what's the total volume of data if we were required to collect all of this information? And I've ran a query here where I'm looking at some systems. We'll just take a look at those results, and then I'll run one live and in color for you guys to show you how readily available and how things have changed for remote access. So in this example, what you're seeing right here is I've actually searched for a list of keywords. I've actually listed no keywords and looked at what the total volumes for 4 custodian laptops are and 2 network private shares for these particular custodians. So quickly I can determine in place, without incurring a significant amount of processing, review, the total number of volume I would have to collect. And in this simple example, it's about 11.2 gigs worth of data, or 83,000 files across both their email and their system. I rarely get off at this stage in my process where we have to take a deeper look at it. And in many cases, I'll end up with multiple keyword searches that people will provide me. And we'll go ahead and take a look at another one of those and see how that examination goes. The good thing about this is the data is living in place. And what we're seeing here is I'm using Boolean type search language. I can use date ranges. I can use proximity searches, exact phrases, and I'm actually interrogating the data. Again, going across network shares, emails, as well as files that are on local hard drives that can be traveling the world, have access to see what content existed. And a simple calculation on this tells me that I went down about 90% in my potential collection using these lists of keywords, which is about 1.2 gigs down from 11.2. One other statistic that becomes extremely helpful to take back and download either as a CSV format is how responsive were the terminology I was using. And I think you do this early, Kelly, as you mentioned. Look at the data early, test it, refine it, see what's going in the front end, see what's coming out the back end, and you'll be able to deal with that and see which results are 0, which ones are returning the most volume, understanding if they're too broad or too tight. You can get all of this statistical information with the data in place. And I'll just keep reiterating, things have changed.
Can I jump in? So from a practitioner standpoint, this is key. This is what the courts, when you read these decisions and they're saying, hey, you need to come to me with more information. this is what they're looking for, and it's not. This is where angels fear to tread. This is what the courts are going to make their decisions based on.
Exactly right. And then here's what happens. This was the original set of data that we agreed upon, that maybe we conferred, and we came back with a really manageable size of data, and it is proportional. Then they'll come back and say, we want to substitute some additional terms into there, and we might want to rerun these particular terms. One easy concept of doing that is simply coming over and adding those new additional terms to the terms you've already previously run, and executing an additional query. The unique thing about in-place indexing, host indexing, being able to reach into those data sources and have a legally defensible index associated to it, where metadata and MD5 hash and all of the forensic practices are being applied, can now in real time kind of do some assessment. Now, you don't want to live here forever. It's purgatory. But what you'll see is you'll start to see the data sets revolve. What I'm showing you here is probably about a 45-second response time. You can imagine that most static eDiscovery systems can't process information in 45 seconds, but we're able to go ahead and maintain an in-place index to look at these large data sets. One other use case that's become very prevalent is around data lakes that exist in enterprises, where they have terabytes of data that was it's unreasonable to allow them to access it, but they don't know what their risks are or vulnerabilities are. And what you're seeing now is the screen will repaint. And if you'll remember, we were collecting at about 11.2 gigs of data with our terms. Adding the additional data in, doubled it. We went to 2 gigs of data. So we'll start to see some additional documents that were not previously targeted are returning unique results because the data volume has increased. So what we're seeing here is the combination of our original terms, adding in the additional terms that might have been required in our second set of terms that we're looking at here with pink and solar, et cetera. But we'll also see how many records they came back. So
and just to be clear, Alan, just to be clear what we're looking at, these are multiple laptops and some file servers that could be anywhere in the world and can be run remotely. So we're not collecting anything. So remember the slide in the traditional process. Previous to this process, when I was involved in case, we had to wait weeks to get at this point. Data had to be, people go on planes, they get full disk images, they come back, they put into a hardware processing service, and then we finally start to get some insight into the data. It could be 2 weeks later. There's a lot of cost that has also been incurred, and these systems are all remote. The index is in place. We're not collecting anything, just getting keyword hits. Just want to make sure that's clear. And then I guess the question for Kelly is that how does this enable you, this capability, to approach like meet and confer, like Rule 26F conferences with additional intelligence?
Well, obviously it depends on the process that you're engaging in for an individual case, right? If you already have discovery, so typically there's a couple of different times at which we will look at search terms. One, we want to look at terms for preservation purposes, right? So whether we preserve by custodian, by date range, by search terms really depends upon the case. Typically choosing search terms before you know what the other side is requesting can be dangerous, where angels fear to tread, I guess. So you might look at it for preservation purposes. The next thing you're going to do is when you have requests for production, you're going to use the results that you get on search terms to be able to determine whether those are how you're going to respond to those requests for production. So typically, if my client receives requests for production, it would be our job to come up with searches that would provide potentially responsive information to be reviewed. And we may agree on those with the other side, but they would be something that we would propose. And we would use something like this that we're looking at today to be able to define those search terms.
And you make an excellent point there about what to do with the data. And the way things have changed is at this point, we were inspecting the data in place, which we might have terms, or we may want to know what our preservation load would be between one date range versus another. The final frontier of actually being able to not only get insight into the data is being able to manipulate it or collect it. One function that has changed in the market today is you can generate load files you can actually publish to relativity if you had workspaces to do additional investigation. You can make multiple bites at the apple and coming back to the well and directly import that into a relativity server or relativity online system. And most importantly, this kind of bill goes back to what we were talking about earlier about targeted preservation. If you export the original files and structure, I can take the CEO's laptop who has departed, retain all of his desktop files, his My Documents directories, all of those particular components in their native format and be legally defensible, and maybe archive that until the time it becomes necessary to investigate it further. So things have changed. We can interrogate in place.
Which is a big savings, right? Because a lot of times we're imaging those entire drives and retaining that data and then storing all of that information when you don't really need to. You really just need to keep the user data that might have relevance to litigation.
Would you rather preserve 57 gigs of data or 182 gigs of data? Right. It's a simple math problem.
Or terabytes, that's right, yep.
Or terabyte of data, it's a simple math problem. 77% cost savings to get user-created content.
And just as another component, Alan, because this is some of what we do, a lot of is we'll spend a lot of time with project managers or hopefully with paralegals working with clients to help them get rid of a whole bunch of data that they've kept and maintained. And then you've got to fire up those entire hard drives, pull out just the information that you might need and get rid of the rest of it. So the management of that data, not just the storage of it, can be exponential in terms of cost.
Absolutely. Remediation exercises in an IT department that do one thing with one tool, which is save everything, create risk around other organizations that we can actually target, preserve, and move on. So that concludes what I was going to show today. I want to leave time for Q&A, and I know we're a few minutes over. So I'll turn it back over to you, Karen.
Thanks, Alan.
Excellent. Yeah, thank you, Alan. All right, so got a couple questions, some really good questions that come in, and we're going to try to get to as much as we can. The first two are somewhat related, so I'm going to kind of present them both. I think, Kelly, these are good questions for you. The first one is from Patricia, and she says, does anyone have an example of responding to a very broad request, such as any and all information? And it seems that Patricia's from a state agency, so as she seems it's concerned about a broad request. The other question from Lisa, which I think is somewhat related, so maybe we'll combine them two, is, again, paraphrasing, if the other side does not agree to reasonable searches and keyword metadata searches for collection, and instead unreasonably demands collection of everything, should we do our own targeted collection and document it and be prepared to defend our effort, or should we take another approach such as seeking a protection order?
So two different questions. I'll take the first one first, which is when you get a really overbroad request for the production of documents. The first thing you have to do is object. And you need to object specifically to that individual request. And then you need to meet and confer about it and try and get a full understanding of what the other side is actually asking for, and then ask them to give you a more narrow request or document what those meet and confer arrangements come to. So we're seeing a lot of case law on fights over what parties actually agreed to on a specific request. So I would say document everything that you do, but you really do need to meet and confer about those things, and you need to be prepared to deal on a motion to compel if something is very overbroad, why it's overbroad. So when you object, be specific in your objections. One of the changes to the 2015 federal rules was to eliminate the ability to use boilerplate objections, and where you do use boilerplate objections in a court that's familiar with the ban on them, they will constitute a waiver of objections for your specific requests. So be careful with that, but definitely be aggressive in objecting to overbroad requests for production, because it's just too difficult to deal with in the ESI space. Ask the second question again for me, John. Bill, do you have anything to add to that?
Yeah, the courts, you'll often hear them say, get us involved early when you see the opposing counsel that's being aggressive and using discovery as a sword. And they'll want you to come to court with if you have to go to court, they'll want you to meet and confer first, but they'll want you to go to court with real data, with real information. They've asked for everything, Judge, if it's everything. It's not so much a dollar amount, but it's here's the kind of things we're gonna have to do, and it doesn't make any sense. What we propose is a much more reasonable process, which looks something like this. So like Kelly said, object effectively and come with a plan.
Right. And so I remember the second question now, which was, what if somebody wants us to engage in a super broad collection process and we've got a very targeted, focused collection process? I would say two things. Timing is everything, and how long it takes your court to respond is a critical factor in what steps you take, right? If you have a judge that has said, if you have discovery issues, I want you to submit a letter to me and we will set up a hearing and do it by phone within 3 days and get it resolved and move forward, I suggest you go to the court and you get an order from the court that what you are planning to do as far as targeted collection and preservation is adequate. That's your best line of defense. The second line is to do what's reasonable, make sure that it is defensible, and take those steps. But if you already have counsel who is hostile and believes that overbreadth is the name of the game, then I suggest you go to the court early and get the court's intervention to tell them right out of the gate that that's not going to be the issue. Where we have done that with clients, with the courts, we have been a lot more successful in fending off many later challenges because the court has, set the bar early as to what the scope of discovery is going to be and how parties need to engage.
And if I could jump in, also include the timing aspect. The overbroad discovery process with a gargantuan data set, let the court know this is a 2, 4, 6, 8-month process what they have in mind. And it doesn't happen in the kind of cases that we're working on right now. The judge will agree with that. What we're proposing, Judge, is a much more streamlined process that will take 2, 3, 4, 6, 8 weeks.
And I completely agree with Bill. You've said it a couple of times now, Bill, that you've got to come with specifics. So, if you juxtapose the number of documents that would be responsive to what the requesting party is asking for versus what your targeted collection is and the associated costs of that for a court to see, and the difference is exponential, it's going to be what sways them. Right? They need actual data to be able to look at to decide what is appropriate. And one of the things that, I actually spent a lot of time educating judges on how costs are dealt with in eDiscovery and what the different costs are, because oftentimes they're being given information by counsel and they don't know what it means. They don't know what hosting charges mean or production costs mean or how they vary between platforms. So be prepared to explain that to the court. Be prepared to tell them, here's the software we're using, here's how much it will cost, here's the difference in cost for us, here's what we've done to ensure that the terms that we are using are reasonable. The more specifics you give the court, the better your arguments are going to be and the better they're going to be perceived. And to Bill's point, those cases that we just went over in the slides specifically address, the date ranges, the types of data, the custodians, all the pieces that you're going to want to do when you're looking at doing reasonable defined collection.
Excellent. Okay, great responses. Let's see, Alan, got a question for you. This goes to remote collections. Question is, how does X1 collect? This is from Jason. How does X1 collect from laptops that are off the corporate network?
Yeah, it works simply the same way you log into your banking application and check your balance and review your statements without being on the bank's network. You're not part of Bank of America or Chase Manhattan, but you're still able to access systems that are housed within their walls. We use the exact same communication method to communicate with those devices over a secure channel, encrypting the data both in transit and at rest. So the simplest way to think about that is you access your bank records without being on the bank's domain. You would access remote laptops with that exact same technology with remote collections.
Okay, great. Let's see, we have a few more that are more on the technical side, so we're going to answer those offline. But listen, I want to thank our panelists, Kelly Twigger, Bill Belt, excellent presentation. There's a contact information. Kelly does this full time. All she does is eDiscovery, so she represents large companies, small companies, is their outside counsel or consults on eDiscovery processes. So would highly recommend Kelly if you have any requirements around the concepts we talked about today, or want to put your process in place, or just need overall legal advice. Bill Belt is at CDS. They are cutting edge consultants that I think are walking the walk on functionality and being efficient for their clients. So, and they've got, as you see from Bill, a lot of smart people there, and to recommend for your eDiscovery consulting needs in terms of getting, applying and getting the work done, CDS and Bill resource. And there is X1's contact information. But again, thank you very much. We'll be providing the slides and answering questions offline as well, and we'll provide a few other resources. But thank you all for attending. It was a great session. We'll have a recording available, which I know I'll be listening to. And but thank you all, and have a great day.
Thanks, John. Thanks, Karen.
Thanks, John.
Thanks, Bill.
Okay, thanks, everyone. Have a good day.
Thanks, Alan.